ultimately, what is a patent? So a patent is a legal instrument that in some cases entitles the holder of the patent to damages. So that's sort of at the high level of what it is. But so what is a patent? So a patent is a document that is granted by the United States Patent and Trademark Office to an inventor. And so what a patent is that essentially is an exchange for a limited period of time. So right now, if you filed for a patent application and got a patent granted and issued, you'd have 20 years from when the patent was filed, from the earliest, what they call the earliest priority date. So, but at the end of the day, it's a legal instrument, and what it does is it's granted based on the inventor's ability to demonstrate that they've provided something useful, that have advanced one of the useful arts that's new. In other words, it hasn't been done before. And it's also a non-obvious combination of what's come before. And if it satisfies those requirements, now obviously I'm using very generic terminology, but assuming that it is able to satisfy those requirements, then the patent office will grant a patent. And that patent grant will allow the patent holder to exclude others from practicing their invention, from offering it for sale, from making it, having it made, from being imported. Now, what is an invention? So, that's again, that's going to be a topic for many other future videos. But to put it simply, a patent has claims at the very end of it, and the claims define the scope of what the inventor's invention is. So, the patent has one or more claims at the end, and the claim is ultimately what defines the invention, and that is what gives. That is where the meets and bounds of that. So the boundaries of the claim are what the inventor can stop others from doing. And so that is what defines the invention. And that is ultimately where what will allow the inventor to then take that patent and then either stop other infringers or potentially going to competitors and offering it as a license. In other words, licensing the patent in exchange for royalties. So for example, a percentage of profits from products sold that practice and use the invention. So ultimately, it's a quid pro quo. So it's an exchange. So the inventor is teaching the public how to make and use their invention. And in exchange, the government, for a limited amount of time, allows the holder or the inventor to prevent others, to exclude others from exploiting the invention. Now, why is that quid pro quo? Why do we have this system? Well, because we want to encourage people to invest in research and development. So we want we want to encourage them, and we want them to know that after they teach others, after they disclose their invention, they'll at least be able to exploit their innovative capacity for some period of time, the patent term, essentially, the life of the patent. And so that, at the highest level, that is what a patent is.